difficulties or challenges. The first one is that he faces a mandate challenge. The mandate challenge is that the statute gives the special prosecutor significant powers. I was going to say wide, but I prefer significant. Significant powers, which includes freezing powers. These are prejudicial power. I mean, prejudicial, not the word prejudicial. So pre-hyphen, but pre-going to court. Prejudicial powers. In other words, powers that the special prosecutor can exercise before he goes to court. When he does exercise them, the courts are supposed to review his request on the basis of, again, the powers that have been conferred on him before coming to court. So in the case of freezing, for example, when the matter is before the court, one of the key considerations the court will have to make is whether the freezing request that has been made by the special prosecutor is necessary for the investigation. So the necessity of the freezing is material. I was not in court. I'm not privy to all the legal processes, so I can't speak to the specific case. But in the context of mandate, it just speaks to an evolving tension between the statute and the established ways of doing things in Ghana. And the established ways of doing things is you have essentially the court that exercises those powers with a certain degree of latitude of discretion. But in this case, the discretion is not really on the side of the court as much as it is on the side of the special prosecutor. And the court is supposed to review the request in the context of the necessity of the powers of the special prosecutor. I have a feeling that the mandate of the special prosecutor faces this significant challenge, but also in the context of the overall criminal procedure of Ghana. The criminal procedure of Ghana, as I indicated earlier, requires that a prosecutor establishes beyond all reasonable doubt that a crime has been committed or established. The defense only has to establish a doubt and the fact that the doubt is reasonable. Once the defense raises this, that's it. I started by putting in context the fact that the special prosecutor, like all prosecutorial agencies in Ghana, come up against this major difficulty, and that difficulty being the fact that their capacity, particularly from a forensic investigatory standpoint, the fact that their capacity generally tends to be limited and affected, and the fact that the defense, on the other hand, rather tends to have the full benefit of, if you like, legal representation, particularly because of the persons involved. And then in addition, all they have to do is the very low bar of saying there is a doubt. The substantive cases of special prosecutor appears to be Herculean. In fact, as we speak, it doesn't appear as if he's even in the mainstream substantive one. These are collateral motions. These are motions that are designed to enable him manage the investigative process. And he's coming against this. So that's the first difficulty, the mandate one. The second difficulty, which is what?
The mandate one.
The mandate one, which is the statutory.
And you spoke specifically about freezing orders. Correct. Which he has the power to freeze people's assets and things.
Correct. Pre-court and during court.
Within a specific period, and then go to court. Now, the Section 38 of the Special Prosecutor Act says that if the Special Prosecutor that has reason that the property of a person or entity, when the property of a person is being investigated, I have highlighted being investigated, right, not after investigation. Then you go to 40. 40 also repeats the same. 41A says when he's satisfied that, when he goes to the court ought to satisfy itself that the respondent is being investigated, that the person you have brought before the court is being investigated. Then in 41F, it says that there are reasonable grounds to believe that a confiscation order shall be made under this act in respect of the property. All of that appear not to be when investigations have been done. A judge gives a different view. Should he not be litigating this in the court? Back to the question. Rather than being in the public and telling all of us that this is what the law says and the judge erred.
Correct. And that is exactly what we're dealing with. So the statute is unmistakable. And judges have given decisions lawyers have had big fights with. Now, as someone who teaches the law, I can assure you that I've been in courts and heard rulings that challenges my knowledge of the law and what I teach. In other words, the fact that I tell students to know the law in one particular way or direction, and then I hear something which makes me wonder whether, what I'm telling students, whether I can still have the confidence to tell them. So this won't be the first time, if that is what happened. It won't be the first time that a lawyer has a serious quarrel with a decision of a court. And that leads to the second difficulty that I mentioned, the perceptual difficulty. The special prosecutor faces a perceptual difficulty given the press conference.
No, you haven't answered my question. Should he be litigating this in press conferences and press releases criticizing the judge?
Right.
Or should be in the Court of Appeal going to the Supreme Court, so to speak?
I am exactly answering your question. And I know you'll probably take issue with that,
Okay.
but grant me this, you take that at the end.
All right.
But I'm exactly answering the question, that the special prosecutor faces the perceptual difficulty, which feeds into the question you're asking about
mandate difficulty.
How he should be doing it. Exactly. Now, the perceptual difficulty is, ordinarily, when lawyers have issues with courts, what they do is simply to take advantage of the appeal processes, to take advantage of all kinds of ancillary legal processes through motions, come before courts, challenge jurisdictions, challenge substantive issues, essentially vindicate their rights. When lawyers have issues with courts, ordinarily, they are not trained to appear before the cameras and to court the court of public opinion. And that's where the perceptual difficulty comes in. Yet, the special prosecutor is not another prosecutor. He is not a regular prosecutor, and he's even less so not a regular lawyer. He is a special prosecutor with a special mandate, a public interest defender. He is someone who is working on behalf of the public with special statutory permissions and statutory allowances. One of the statutory permissions is that the special prosecutor is allowed or enabled the opportunity of appearing before the public and giving feedback. The question then is, what is the scope of the feedback that is allowed? What is the character of that feedback? What is the degree of specificity that he should give? What is the extent to which he should particularize cases? Should he limit himself to trend analysis as he sought to do, but there were particulars? The difficulty some people may have is the particularization, the fact that there were specific cases that he mentioned. But then again, his argument could be, I do not want to speak in the abstract. I do not want to just generalize and speculate. I want to be particular so people know that there are bases to what I'm saying. But the point is what I laid out earlier, that perhaps he can be given a little flack, given the fact that he doesn't have a real template that he seems to be working with. So my sense is that he was giving the public the feedback. He may appear to have gone into some specific details, and the problem with those specific details is that they may actually even sin against a cardinal legal rule, which is the fact that matters that are sub judice, you do not publicly comment on them in terms of the degree of specificity and in terms of the particularity with which you speak on them. These are difficult tensions. And the reason
So for every matter he commented on, he had already issued a press statement. And he does it the very moment the decision is made by the courts.
Right. The point I'm making is we have an evolving scenario. That evolving scenario may appear to be in tension with certain establishments of doing things, at least from the professional standpoint. But he has statutory permissions, or he has statutory allowances under the Special Prosecutors Act, the Office of the Special Prosecutors Act. Therefore, he appears to be in a peculiar terrain. As I indicated, what the law doesn't give are the extent of details, the extent of particularity, the extent of peculiarity with which he can report. And so he's given a report which appears to be going against or being in tension with professional etiquettes and professional ways of doing things. But that's why I'm saying that perhaps he can be allowed the initial reports which we appear to be having at this stage, i.e. the fact that there are no real templates, and he may be evolving in the respect. I think moving forward, perhaps he may want to limit himself to trend analysis and the generalities of things.
But is there really a problem